All right. Question from New Paltz, New York. My sister is sole heir for an estate. The lawyer executor has not given her any information on the estate. She has not she has not had the will shown to her, nor seen what bills need to be paid and what has been paid. She wants to sell the house and the contents, or he wants to sell the house and the contents. Should she get her own lawyer to make sure he is doing nothing underhanded? He had been in trouble years ago for ripping off a client. All right, so let's take these one by one. The executor has not given her any information, shown her what bills need to be paid, what will be paid, and wants to sell the house. So the normal order or procedure in New York is that once an executor is appointed by the court sort of gives the executor like a lot of leeway to conduct estate business and show his work at the end. So there's a part at the end of the estate, at the closing stage of the estate, where the executor pretty much has to show to all the heirs something called an accounting. And the accounting is the line by line, like books and ledgers of the estate that'll show the heirs, in this case, the sister, everything that she's asking to see. What bills were there, what bills have been paid, what he sold the house for, and what he got, closing costs, all that stuff should be shown in a line by line itemization. When she asks, so that information is not always going to be made available on a live basis, because that can create more costs. If the lawyer has to sort of check in and update every time he does something, if the executor has to do that, that can actually make the process slower and more expensive. That's sort of the reason why it is the way it is. That being said, transparency is always better, and if it's not too much trouble, then you can ask the executor to show those things. But so that's the general order of how estates work here in New York. Should you get a lawyer to make sure he's doing nothing underhanded? I'm not sure how that would benefit, because let's just walk through this. If your sister hired an attorney right now, the best that lawyer can do, your sister's attorney could do, would be to sort of establish communications with the executor. Unless like an obscene amount of time has passed by without anything happening, unless it's been like a year since the executor has done anything, the best that you can do is go to court with your lawyer and say, I want to see an accounting of what's happened so far. And the court, first of all, if it hasn't been a long time, might just decline and not order the accounting. Or in the best case scenario, if the judge does order the accounting, that's actually going to diminish your sister's share in the estate, because that costs money to produce and create that record. So at best, your sister's own attorney would be able to maybe establish contact, get some communications, maybe get a few better answers, just because the attorney executor knows that another attorney is kind of looking over their shoulder. But don't expect. I guess my advice is don't expect any major changes. But your sister is right to realize that the attorney who is the executor does not represent her. He is not her attorney. Rather, he represents himself as the executor for the estate. So it's good that she realizes that no attorney-client relationship exists in that regard. So if she does feel like she needs her own attorney for her own protection, go for it. I've just explained, though, what the procedure is and how it may not necessarily help. So when the attorney executor does prepare his accounting and shows it to your sister, that might be a really good time to hire her own attorney to review and make sure she's comfortable with what's been disclosed, what's been reported, before signing off and accepting her share as her inheritance. All right? Hope you found that helpful. Take care.